Good evening. Welcome to Be Informed. My name is Carl Buhariwala, and I founded Be Informed to help people make good decisions. Today, we're looking at workplace discrimination, and we are joined by a friend of Be Informed, Paul Cott of Law and Lydiard, who will be taking us through what rights you will have in relation to workplace discrimination issues in Australia. Before I proceed, I would like to acknowledge the traditional owners of the lands on which we're meeting today and pay my respects to their elders, past, present, and emerging. Today's session is being conducted in Australia and will refer to the Australian laws. So if you are looking at this presentation from a jurisdiction outside of Australia, please do reconsider its application to you. And the information presented in today's seminar is current as of this month. So if you do rely on this session and the contents of the seminar at a future time, you may wish to reconsider if it's applicable or not. In terms of housekeeping, if you have any questions, please send them through to me in the chat function, and I will then relay them to Paul during the Q&A session, Q&A component of today's session. Today's session is also being recorded, so if you have to leave early or jump in and out, don't worry. You can watch the full session online through our YouTube channel. And Paul has also kindly prepared a one-page handout, which I will share to registered participants following today's session. And you can use that document for yourself or share it with family and friends. So without any further delay, Paul, I'll hand over to you to talk to us about workplace discrimination. What are your rights in Australia? Thank you, Paul.
Thanks, Carl, and good evening, everyone. If you just want to bring up the first slide, and that is, what is workplace discrimination? And I get a lot of comments in my work where somebody is treated less favourably than somebody else, and they say they're being discriminated against. So the definition of discrimination is around being treated less favourably, but it's not just generally, less favourably, unless it's for a particular reason, the protected attribute, which I mentioned there. And it has to be that the less favourable treatment is caused by that protected attribute. So I'll read it, which are pretty common amongst the anti-discrimination legislation which we have at Victorian level and Commonwealth level in Australia. And it's to do with, the protected attributes are to do with a person's race, colour, sex, sexual orientation, breastfeeding. There's some new additions to this, such as this one: gender identity, intersex status, age, disability, being physical or mental, marital aspect, responsibilities, being subjected to family and domestic violence is another relatively new one that's in there. Can't discriminate against somebody because they're a victim of family and domestic violence. And then pregnancy, religion, political opinion, national extraction, or social origin. It's got to be to do with one of those things which causes the less favourable treatment. So as I've said there, the concept of protected attribute is critical. So just because an employer may, for example, not like someone or like someone a bit more than the other person, and they therefore say this person's going to get a promotion, the other person doesn't. In that sense, there is some discrimination because they've chosen one person over another. But unless it's linked to a protected attribute, it's not lawful discrimination or unlawful. It might be unethical or immoral or inappropriate or against HR policy and various things, but it's not against the law to discriminate someone unless it's linked to an attribute. Discrimination can occur for more than one reason. This concept is quite common in the law. Various things happen for more than one reason. Somebody does something for more than one reason. Often a person has a different, a mixture of motivations or intentions as to why they did something. So generally, if the discrimination occurs for another reason, not a protected attribute, which we'll mention, as I said, it's potentially unethical, but there's no legal protection. But if there's more than one reason, so there's a valid reason, such as performance related. So let's say we're looking at a promotion. This person didn't perform as well as the other person. but the other person, sorry, the better performer is of African origin. Let's just pick an example, and that if that person with African origin is a better performer and they're not chosen for the promotion, then we're going to have some discrimination. It's important to know, to mention too, there's two types or broad categories of discrimination. One is called direct discrimination, and the other one is indirect. So what direct discrimination is, just like I just said then, where we say somebody made a choice that somebody would not get promoted because of their race. Indirect discrimination is a lot harder to pick, and it seems that there's not discrimination going on. So I'll give you an example. The employer makes it mandatory that all team members in a workplace must have a in-person meeting at the head office at 8:30 every Wednesday. So let's say every Wednesday and Friday at 8:30 in the morning. So that is not discrimination. How can that be discrimination? But how it can be indirect discrimination is because of the effect of the discrimination. Sorry, because of the effect of the requirement for the attendance at those meetings. Mothers with childcare arrangements, or even fathers who have to drop off kids at school, would not be able to attend those meetings. So the effect of that requirement is discriminatory against single mothers, which is a breach of a family and or a carer responsibility under the Fair Work Act, and potentially under the Commonwealth anti-discrimination legislation and or the Victorian one. So as we say there in that last point there, legally outlawed discrimination is prohibited at all stages of the life cycle. So from first contact all the way up through the interview process. So if there's a person who is not chosen because of their colour of skin, for example, again, and they may be better qualified for the position, but if they're not chosen because of their race, even if there is another reason, then it may be that it's discrimination in respect of a prospective employee, which is a legal protection that employee or prospective employee would have under the Fair Work Act and under the anti-discrimination legislation. And the protections available in the workplace go through all the way through from first contact to interview to onboarding to the employment life cycle or during the employment life, all the way through to the ending of the employment, and in particular, the ending of the employment is also a relatively more common situation where an employment is ended because of a discriminatory reason, which can give rise to a general protection claim under the Fair Work Act, and which we'll get to that shortly. So the next slide talks about who is protected by the discrimination laws in Australia. Basically, all employees, as I've said there, and even volunteers, even students on work experience, and even contractors. So, for example, if a black fellow turns up to a workplace and he's a contractor, so he's not an employee, to deliver a parcel from the business, and the business was to ring up his employer and say, we don't want that guy here to deliver the products, and whether they state it or not, if the reason is because of their race, then that contractor, even though he's not an employee, and even though he may never return or never been planning to return and never been in the workplace before, can get some protection around the anti-discrimination laws. And as I've said before in the previous slide, applicants who are merely being interviewed for a role can be discriminated against. The problem, though, with that is that it would have to be a pretty silly employer to admit that they made the choice to choose another candidate for the reason, for the unlawful discriminatory reason. So it's going to be very difficult, and it's a matter of proof for the employee to say, well, I didn't get that role. I don't really know why, but I suspect it's because maybe because I'm pregnant, says a female candidate who didn't get the role. But she doesn't know all the other candidates. She doesn't know what their qualifications were, how they stacked up. All that she may well have is a suspicion that it was because she was pregnant that she didn't get the role, which is a difficult one. And legal claims should not ideally be based on mere suspicion, just a bit of a guesswork and a bit of a feeling that I was discriminated against, and not because anything to do with I wasn't the best candidate. So that's a difficult one for a prospective employee to enforce, which is a fundamental a fundamental concept in the law, which I was told many years ago, that there's a difference between having a legal right and being able to enforce it. I don't know what the anecdotal evidence shows people not getting roles because of some attribute and what the statistics are, because obviously, as I say, people are not admitting it. There's a problem of proof. That one's a hard one for an employee to allege. And really, it's a matter of evidence as to what's the evidence that they have that they were discriminated against because of their protected attribute. What's their evidence? Is going to be a very difficult one. So we just move on to the next slide. Options to resolve, which there are many. At first instance, as with most legal issues, if you can resolve the issue at local level, so to speak, or at lower down the chain, so to speak, all the better. Consider a report to your supervisor, manager, and or the HR department. Now, these are often the best and quickest and obviously cheapest options. They're at no cost. But there can be cases and employment situations where it's not appropriate to make the reports to your supervisor or your manager, or there might not even be a HR department in the employment, in the workplace. So you don't have that. And it might be that you're discriminated against by your manager or your supervisor or the owner of the business, and there's no other employees. So there's nobody to report to there. So the next option is that the Fair Work Ombudsman does have some role in enforcement of employment or industrial relations laws across Australia. They have not an overly active role in receiving reports and acting on reports of discrimination. And we query or question how often they enforce these laws in an individual case. The cases I've been involved in where the Fair Work Ombudsman takes matters to court or really gets active in enforcement and enforcing their role is where you've got a large number of employees who have been affected. So they can see that there's a pattern of behaviour where there's numerous reports to the Ombudsman on various employees over time. That's when they may then get in and issue proceedings or legal proceedings or actively communicate with the employer. So, but it is an option that employees do have. A letter of demand can be sent by the employee or through a lawyer. I mean, what a letter of demand, as the wording suggests, is a letter setting out what's happened, why you say you've been discriminated against, and what you say should be the outcome of it. And in a sense, there's no real rules about what can be asked or requested of in a letter of demand in a discrimination context or any other context, but things like demanding that the discrimination stop, that the benefit be given that they were denied because they were discriminated against. Compensation is a big one. An apology is sometimes sought, but not always given. And employers are often, and to be honest, with good reason, a lot of the time, a bit reluctant to put an apology in writing because it can be construed as some sort of admission of any wrongdoing and admission of liability. Legal advice and assistance and representation should be considered. If you do issue a claim in the Fair Work Commission, what's called a general protections claim, you should get legal representation because there are legal issues in a case like that. If you're terminated from your employment for not a valid reason or for a reason that is discriminatory, it also could be unfair dismissal. You don't necessarily have to get a lawyer for an unfair dismissal claim, but if the employer turns up at the conciliation with a lawyer or is going to be represented by a lawyer, which you'll find out through the paperwork, then the employee generally should get a lawyer themselves to level the playing field. Community legal centres can assist you in these areas as well as others, although they and or legal aid do have means tests. You can't automatically see a community legal centre or legal aid to get assistance, and they generally don't, or both legal aid or community centres do not actually represent you or commence cases in this area or other areas apart from family law and criminal law, not really discrimination. As you said there, a claim can be made to the Fair Work Commission, which is basically the most common one, saying you terminated me, for example, because I'm pregnant, or example, because I'm Chinese, things like that. A general protections claim, a little bit similar to an unfair dismissal claim. The process is relatively the same with a claim to the Fair Work Commission. It's called a general protections. Why it's called that is because an employee has a set of general protections in the workplace, such as to have a healthy and safe work environment, and not to be bullied, and not to be sexually harassed, and of course not to be discriminated against. If there's discrimination, then one of those protections has been breached. You can make an application to the Fair Work Commission for a general protections application. You can just make an application like that straight to a court and bypass the Fair Work Commission, go to the Federal Circuit Court or the Federal Court of Australia. The state and the federal Human Rights and Equal Opportunity Commissions both have a pretty big role in this area. They particularly, you don't need a lawyer in those avenues. They're not overly legalistic. They're quite informal. There's no costs involved, I don't think, in either of those commissions. If you get a lawyer, there might be a cost. And they're a relatively informal process that usually is commenced online from their website. Just make a complaint to the state or federal Human Rights and Equal Opportunity Commissions. And with the outcomes that you'd be seeking in the commissions, really anything goes as long as it's by agreement, and obviously as long as it's appropriate, not unlawful, and not immoral, and or breaching any other law. So now we go to the next slide, which is legal protections available for dismissal. I have touched on this a little bit before, but as I said before, a general protections claim, that terminology is often used interchangeably with an unlawful adverse action. What that means is an employee says, you took unlawful adverse action, the adverse action being termination of employment. You took that unlawful action against me for a prohibited reason, and therefore I'm entitled to a remedy in a court or by the Fair Work Commission. As we talked before, the discrimination is not at large. I think that those lists of the protected attributes there are the ones that I read out. And there's been added more in the relatively recent changes to the law. A dismissal from employment could definitely lead to a valid unfair dismissal claim, as obviously it's not a valid reason to dismiss someone for a discriminatory reason. So I guess an employee has to make a decision between, do I go for unfair dismissal because I was discriminated against, I lost my job because of it, or do I launch a general protections claim instead? Broadly speaking, and that's probably another session potentially on the differences between the two types of claims and what outcomes can be sought in the process. But very broadly speaking, the processes are pretty much the same. You should get legal advice as to because there's so many factors that go into it. Should an employee lodge a unfair dismissal claim in this situation, or should they lodge a general protections claim, which, as I've said there, you can make to the Fair Work Commission or to the Federal Circuit and Family Court of Australia or to the Federal Court of Australia. Obviously, as a broad general proposition, a claim made to the Fair Work Commission is probably cheaper, quicker, and certainly less formal, and potentially more remedies are available and can be sought in the commission as opposed to those two courts. Obviously, when you get up into the court hierarchy, you've got the Federal Circuit Court and Family Court of Australia and the Federal Court of Australia. They're high up in the Australian legal system, and basically above them, you've got the High Court. So they are pretty high up in the court and quite formal. And you probably really do need to have a lawyer to even commence a claim in one of those courts, let alone to run it. So on to the next slide, which is remedies, which I have touched on, but really remedies are at large. Now, a lot of employees say, I've been discriminated against because of a disability, for example, so I want an apology, which is not an unreasonable thing to ask for. However, it's certainly my experience that I don't remember one claim where an apology was agreed to be given. The court can't order an apology. The Fair Work Commission couldn't order the employee give an apology. An apology would only ever have to be given voluntarily by an agreement by an employer, apologising for the conduct. They're reluctant to do so because then it's seen as admission of liability. But then you say to the employer, well, how about we suggest that the wording be, without admission of liability, I apologise unreservedly for any offence that the discrimination caused. But then the employee says, well, I'm not happy with that because it says without admission of liability. So they're not really, it's not a genuine apology. So as we said though before, reinstatement to the position in cases of unfair dismissal can be achieved. Again, quite rare. Compensation, they are usually the main things. Unfair dismissal applications which are based on no valid reason. You can also get a statement of service, which is a document on the employer's letterhead outlining the period of employment and the duties done. And you can agree with the employer that the dismissal or the termination is recorded as a resignation. That can be of assistance to an employee if they then go to another job. I can't imagine it'd be a very easy thing to do to tell a prospective employer that you were terminated in your last employment. That can be done by agreement in the Fair Work Commission in the conciliation process. As we say though, the stakes are higher in court, the costs are higher. You probably do need to get a barrister or a solicitor at least, and the employer can be fined if the court found that some discrimination has occurred, and the fines can be really large, particularly where the employer is or was a company that employed it's in penalty units, and even every year, even the penalty units go up. So those fines can be really large. An injunction can be awarded, which is basically an order from the court compelling someone to stop doing something or to compel someone to do something. So in this context, there would be an order of the court prohibiting the employer and or other employees potentially, of course, from continuing to discriminate against that employee. Just a couple of points I didn't mention before. With discrimination, the person who's doing the discriminating does not have to intend to discriminate. It can be inadvertent. They don't have to have a motive to discriminate. And as I said before, there can be multiple reasons. As long as the discriminatory conduct has been substantially caused by, even if there are other reasons, the unlawful reason. I think that's the last slide, isn't it, Carl?
Yes. Yes, thank you, Paul. So Paul, he's a friend of Be Informed. He's presented multiple seminars over the past 2 years. So thank you again, Paul. Paul's details are on screen. So if you have any specific queries, please do reach out to him directly. This session is general information only, right? So if you do have any specific queries about your personal circumstances, reach out to Paul or another professional in this space. Today's session is being recorded, so if you have joined late, you don't have to worry. You'll be able to watch the entire sessions online on our YouTube channel. And Paul has prepared a one-page handout, so you can refer to that document after today's session, which contains a summary of all the subject matter raised by Paul. Paul will now jump onto we'll head into Q&A. And from the outset, Paul, just one question.
Just before we do that,
Yeah.
TW has said that it was a great presentation, so I wanted to say thank you for that. Thank you for that comment.
Nice, that's great to hear. So Paul, just one question that we got ahead of time by email was just around the incidence of workplace discrimination. Paul, in your experience and over time, have you seen sort of a trend in it going either up or down, or what sort of your view just from a perspective of the incidence of workplace discrimination in our Australian workplaces?
Yeah, I think it's going down, but not enough. And I'm surprised in a way that it still happens. Every time I see it happen, I wonder how it could have happened. Where we all know, I think most employees, just quickly then, if somebody's discriminated against work, it might be another employee. It doesn't have to be the employer who's done it. But getting back to the question, it still happens, but it is on a downward trend. And I think that it's a bit indicative that the laws have recently changed, adding in more grounds for discrimination. So the world's changing. You can't now discriminate against someone, for example, because of the job that they do. I won't obviously name a name, but there was a case where I was involved in a couple of years ago where the employee was a sex worker at night in a different, in her second job, and her first job said, "We don't think that's appropriate, and we're going to terminate you." And now that's actually unlawful. You cannot discriminate against someone because of the work that they do. I can't remember the exact phrase, but it's in the legislation now that is a discriminatory reason.
Mm.
Even though the employer may have had some alleged good grounds to be concerned about the work that was being done after hours, because of how it may reflect on the main employer, or the day employer, so to speak. It's actually a discriminatory reason to do that now.
Yeah. And Paul, just sort of a little segue from that point. Can you just remind everyone is there a material difference between the sexual harassment changes that came through, that this is sort of a proactive duty that came out sort of late last year, and the workplace discrimination laws? Is there any nexus between the two, or they're sort of independent of each other?
Yeah. Well, sex discrimination at federal level, under its own act, sexual harassment is linked to discrimination. Often, if you read a legal textbook, or if you read a non-legal book or publication talking about discrimination, they talk about humiliation and bullying and sexual harassment and victimization and discrimination all in the one overall arching thing. So they are all linked. Sexual harassment has now got its own pathway into the Fair Work Commission. You can make an order, or you can apply for an order, as you can for bullying, to the Commission for an order to stop, for the bullying to stop, or for the sexual harassment to stop. You can't make you can't make an application for an order that the discrimination stop unless you go to a court and seek an injunction. So they are linked, sexual harassment and discrimination, because they're all occupational health and safety risks. They're all potentially a valid reason to terminate somebody's employment if they're sexually harassing someone or discriminating against someone, they potentially valid reasons for termination. So yeah, they are linked totally.
Thanks, Paul. And Paul, another question that we've got is just around for business owners, without sort of getting into sort of, I guess, the risk and compliance aspect of it, but from your experience, what sort of controls can business owners put in place to assist with, I guess, mitigating this risk?
Well, that potentially opens up a very big can of worms, because I think it's becoming harder and harder with more regulation for employers to do the right thing at all times in relation to their legal obligations, because there is now a positive duty on an employer to prevent this, not only the psychosocial hazards, which is a relatively new phenomenon, but also there's a positive duty to take reasonable steps. So an employer has to actually do something to prevent sexual harassment or bullying, or discrimination, all those types of things. Which would be policies, education, monitoring the workplace, receiving complaints, dealing with them in a timely fashion and in a professional way. All those things link in to what steps did they take to prevent it either occurring, and what steps did they take to deal with it when it did occur or when a complaint was made. There's a lot to come across for a business owner.
Yeah. And I think in relation to that question, you might want to sort of seek further advice about, what systems and processes and other controls you could put in place, and from an
Yeah.
organizational and operational
I
perspective.
mean, as a practical level, I say that, when you onboard a new employee, you should say, look, here's our policy for equal opportunity, here's our policy for anti-bullying, here's our policy for sexual harassment. Have a read of it. Some employers, the bigger ones, will even make you do a test um, to show that you passed, and so that way you can come on board, so to speak, with the employment. You can give them policies and procedures, um, and say, look, our policies are available. You want to have a look at them? Or the employees don't really look at them. Yeah, no worries. I'm aware of the policy. Thanks for that. And then an unfair dismissal comes along, and the employer says, well, we told and gave the employee a copy of all these policies when they started. They've now breached the policies or the procedures or the code of conduct. And so the employer argues to say, well, we gave them all that information and documentation when they started, so we deem that they knew about it. Whereas in reality, um, let's be honest, most employees don't have the time or the motivation to sit down and read their employer's policy documents and their procedural manuals, which could be 100 pages long. Ideally, yes, they should. And as I said, some employers will make sure that the employees do, and they'll do a test on them, and they have to pass to get on to the next stage or to be employed. But the reality of it is, um, when you say education, well, this is just my own view. I think most employees or most businesses know that they shouldn't discriminate. So the education um, aspect doesn't really take you very far, because we all know we shouldn't discriminate. We all know we shouldn't sexually harass on those types of things. But human nature being what it is, sometimes we transgress.
Mm. And you're totally right. Like, even though you've called that it's on the decline, I think there's still an incidence of it in society. With, you see it in the private and
Yeah,
public. There's
well, it is, and you
Mm.
still see incidences of racism. And
Yeah.
every time I hear about one, particularly, I'm not sure if you or any of the viewers or listeners are AFL fans, but you always hear about, there's multiple instances every year, even this year, as a fan has been racist towards one of the players or at the ground. You think to yourself, how could that happen in this day and age? It's not about education. They know that they shouldn't do it. They just do it anyway. But anyway, that's another subject.
Yeah, but and you raise an interesting point, because so does, in the AFL context, the game itself, when they play at the stadium, right, that is their workplace, right? So fans
Yeah,
that make inappropriate comments are effectively contributing to that workplace discrimination, right? So even customers at businesses can also probably be caught by that, and then it depends on how you deal with it, right? As an employer, that's an interesting point. And Paul, just to remind our viewers, this one quick question has come up. Does this apply to volunteers? So are volunteers protected?
Yes,
Yeah,
all these laws apply to volunteers.
yeah,
Yeah, volunteers, even apprentices, um, students on work experience. As I said in the presentation, contractors, even a postman can't go there and put something in the letterbox and have racial slurs abused, and that's discrimination. That's unlawful. So even one incident can be unlawful discrimination that could give rise to a legal claim.
Yeah, definitely broad spectrum. Paul, you talked about sort of the avenues that individuals can pursue. First to speak to the employer and sort of understand more about what's going on there and getting them to sort of do something rather than overlooking it or putting them on notice. Is that always a recommended course of action, Paul, or should they go straight to a letter of demand? This person sort of querying whether that internal sort of discussion might further exacerbate the issue rather than deal with it. Sort of it depends on the strength of the HR team and how good
Yeah,
the is in managing that. But I guess it sort of needs to be assessed on a case-by-case basis, right?
yeah. It really depends on the circumstances. There's certainly a lot of times where I hear from the employees that there's nobody that I can go to. I don't feel comfortable to go to anybody. I raised it with HR and nothing happened. I'm not making a slur on HR people whatsoever. I've got relatives at HR who are HR people. I'm hoping one of them's here tonight, but anyway, hopefully she'll listen later. So there's a lot of times that employees don't have anybody to go to, or if they do, they're not comfortable to do it.
Mm.
Or is it going to be treated seriously? And then they make a complaint and they're worried about some backlash. Am I going to cop some backlash if I make a complaint from the person who's doing the discrimination and or from the employer? So there's a lot of cases where I recognise that an employee does not have anyone to go to in a practical manner. They just don't. And so they have to seek outside help.
Mm. And Paul, this actually goes nicely to another question we've got, and I'll move that one up the list. This is just about whistleblower protection. Paul, in your experience, there's definitely would be a nexus between the two, right? In terms of raising, blowing a whistle, I guess, on someone who's perpetrating discriminatory behaviors. Could one sort of explore that option to raise an incident through the anonymous, whistleblower channel?
Sorry, I'm not understanding the question.
So if someone is aware that there's an individual, right? I'm just trying to make sense of the question myself as well, Paul. So if someone is an employee is aware that someone else is being discriminatory in the business, doesn't want to approach the employee directly because, as we just discussed, there might be sort of sensitivities around that. Could they raise a whistleblower issue right through the whistleblower sort of framework, and then get the
Yeah.
employer to look into it, and that way there's sort of one, they get some protection, I guess. Do you have any experience with that being an option?
Yes, not practical experience in the sense that I've
Yeah,
been involved in it, but I think a lot of legislation has whistleblower schemes that people can take advantage of. But yes,
yeah,
there
yeah. I think
has
it's
been
something.
the odd case where an employee has taken advantage of the whistleblower scheme and also raised issues separately to that in another forum or in another way as well. Yeah.
Yeah. I think to the individual that asked that question, I think just probably double check, with the professional sort of the scope of the whistleblower regime, because I do know that it's not sort of open ended, right? You can't just raise any type of issue through that regime with the employer. It's only
Yeah.
the certain, I think, financial related or fraudulent related type scenarios. So this might be probably out of scope, but if there is a nexus with the in scope component, then you might be able to use that channel. So best probably to speak
Yeah.
specialist advice on that as to how to explore that option. Um,
That's right.
Yeah, no, thanks, Paul. And Paul, you mentioned just this is one of our last questions, but with the protected attributes, right? And you've got that sort of that list that you shared on your on one of the slides. Is that an exhaustive list, or could there be other ones? Do you see any other novel ones coming through, or is it limited to those
Um,
expressly on the in the legislation, I guess?
there's a really good resource that I've got.
Mm,
It's called Victorian Discrimination Law, and it's on a legal website that we call OSLI.
yep.
So for people who don't know, I think it's short for Australian Legal Information Institute. It's a website, and it's got legislation, case law, and so forth on it. There's a document there, um, and it's absolutely brilliant um, because it has the types of discrimination, protected attributes, areas of public life, all various things, all the way through the whole life cycle, so to speak, of discrimination. In terms of protected attributes, um, there's a category in that document, um, and it has yes a whole lot more. So that's a really good point because there are more. So the Fair Work Act protected attributes are not exhaustive. There are further.
Yeah.
There's even obviously disability, industrial activity, protected attribute. So you go on strike or some action they have with a union is a protected attribute. Um, even personally associating with someone with a protected attribute. Spent convictions as a protected attribute. So that's a common thing where, you've got a criminal offence that happened, say, 12 years ago, and you shouldn't be discriminated against on that now because, and I'll be very brief because that's not my area, but there's a spent conviction scheme in Victoria,
Yeah.
which basically means that after a period of time, those convictions can or should disappear. Even expunged in the same vein, expunged homosexual conviction is a protected attribute. Religious belief or activity, I didn't mention that. I'm not sure if I mentioned that. Profession, trade, or occupation, which is the one that I mentioned where the sex worker was working at night. It's got physical features as a protected attribute. So I'm not sure. That's the first time I've seen that one. Parental status, marital status, lawful sexual activity, and employment activity. So if you do something at work, you shouldn't be discriminated against on that. So yeah, there's a lot. Also, breastfeeding. I think I mentioned that. Gender identity, um, pregnancy, race, religion, sex, sexual orientation, spent convictions, and a personal association, whether as a relative or otherwise, with a person who is identified by reference to any of the above attributes. So
Wow.
just one I haven't mentioned tonight at all, and just going to diverge very briefly. There are defences to discrimination. That is a whole new area. A whole big area. It's another area in itself. People can apply to VCAT to get them to declare that there's an exemption. Religious bodies have a lot of exemptions. Um, there can be age-related exemptions, such as you can't get a driver's license until you're 18. That's an exemption. So there's also especially in the employment space, inherent requirement of a role. So say this is an example I'll give just to illustrate the concept, but it's a bit of an extreme example. If you've got somebody who's got a disability, as in they've got one arm, they've lost their one arm, in an injury, so then their job was manual labour. Inherently, they can't do the job anymore, and the employee might say, "Well, you're discriminating against me because I've got a disability," but that's actually a defence. That if somebody can't fulfil the inherent requirements of the role, in other words, lifting, then that can be a defence to discrimination. So I am diverging. But yeah, there are a lot of defences. Interesting area to read, and VCAT can declare certain things to be defences, and so you can, so the women's clubs, men's clubs, those types of things. There's a lot of defences around. We could almost do another session on the defences of discrimination.
Yeah,
We
that's
really
probably
could.
something in the future, Paul. That's great, and I think that sort of canvasses the other side to a lot of this as well. It's with any right, there's always a view from the other side that might be expressed, so the employer can definitely think about those in instances where it's been
Yeah.
alleged that there's been a workplace discriminatory act or omission. So,
But
beautiful.
I think that list of protected attributes to me might still change. I think it's expanding as the community changes and various things are recognised more than what they used to be prior.
Yeah.
Those lists of protected attributes may well be added to, although it does sound very, very exhaustive, but it may well be that there's still more to be added over time.
Which makes sense, right? So it's sort of discrimination is a term that I guess is driven by community expectations. It's not a it's a term that's probably evolved over time, and you could even think probably activism as well. There's a lot of people very passionate about environmental, social, and governance type issues, or climate change, or issues around modern slavery, etc. So you could see where further protected attributes could potentially be developed
Yeah.
over time. But Paul, that was a really great session. And thank you for sort of going through all that. I'll just share Paul's details again once on screen. So if you do have any queries, please do contact him directly. And his details will also be on the one-page handout as well that you will receive if you're registered, and you'll get that by email. So just that brings us to a close. And so thank you for joining us. Today's session is being recorded. So if you have joined late, don't worry, you'll be able to see the entire session on our YouTube channel a bit later tonight. And I'll be sharing that one-page handout as well. So you'll have that tangible copy on hand and you can use that or share that with family and friends. Please do follow us on social media. I fund this entire sort of be informed myself, and I run it myself as well. And that way, I sort of keep it independent of any private or public or any sort of other views or biases. So it's fully objective, and my sole sort of motivation is to help people make good decisions. And Paul is a very experienced individual, so I'm hoping you've learned something today. Our next session is on July 31st, so that's the Wednesday. And we'll be looking at the budget changes that have come out of this year's budget from the federal government, and also any sort of the key sort of tax changes that will be applicable from 1 July this year. So if you want to learn more about that, please tune in. There are other sessions as well that we've got booked in for later this year. So visit our page on Eventbrite and you can have a look at those. You can register and then also share relevant sessions with family and friends in need. So that brings us to a close now. Thank you again, Paul, for your time, as always. And
Thank you. Thanks,
then bye.
everybody. Thanks, Carl.
All right, thanks all. See ya. Bye.
Thank you.